Hi, I'm Eleanor Piddock, Associate Solicitor in the Family Law team at Aaron & Partners, and I'm here to answer some common questions about collaborative divorce. A collaborative divorce is when a divorcing couple uses the collaborative process to reach agreements between them about financial settlements or children arrangements. Both parties and their lawyers meet together in one room for a series of joint meetings where all the negotiations happen and all the advice is given openly in the room. The parties and their lawyers all sign a participation agreement promising not to go to court. Because the collaborative process is bespoke, the separating couple can choose to involve neutral professionals such as an accountant, a pensions expert, or a financial advisor. The process tends to be a lot more efficient than using written correspondence because we can get so much done together sitting around the table in a few hours. And it's also usually a lot kinder than the more traditional approach, and certainly much more efficient than the court timetable. People shouldn't make the mistake of thinking that collaborative law will be easy. Although it has been designed as a more amicable and kind process, it will still be emotionally demanding. There will be difficult conversations, but collaboratively trained lawyers have been trained in managing those moments to help clients keep the focus on reaching a settlement amicably. The collaborative process is great because it invites couples to think about the interests of their whole family and find creative solutions that work for them. That might mean a clean break settlement, or it might not. It should mean that they have more freedom to agree a less typical solution than a judge might impose on them in the court process. The collaborative process was designed to help couples sort out their issues together more amicably, but the collaborative lawyers are there in the room to ensure that they've had all the relevant advice they need. That means that they've considered the short-term and long-term implications of any proposed settlement deals, and it means that the lawyers will still be raising all the relevant points that they would have raised in written correspondence or in court litigation, but perhaps just in a different tone. The collaborative process is an alternative to going to court, where both parties and their lawyers sign a participation agreement promising not to go to court. In very rare instances where the collaborative process does break down for some reason, then those parties can still go to court, but they have to instruct new solicitors in that litigation, which is a further incentive to make the collaborative process work.